Selfie. Proof you're in class? Oh, is that it? They're not in class. Still hosts the game. Okay. Welcome back. Happy Halloween, I guess. Everyone bummed, I'm sure, or at least most people. I played last night flying home, and the game was on, so I was like really excited until the end. Then it just turned the channel. It was kind of cool, but we got back and wasn't so happy when we landed. Jack-o'-lantern. I like it. Very good. Someone's into the spirit. Is it too cold for trick-or-treating today?
Yes.
I think that's probably... I have an entire bucket of pocket constitutions which are not going to be given out today. No, they love it. They love it. Are you kidding me? Oh, candy with it, but you get the sweet, you get the trick, and then you get the treat, the constitution, right? Oh.
Is that the trick?
I'll let you decide. The parents like it, at least. All right. We are now. We are now almost to the end. 1 second. We're almost to the end of the semester. We only have a handful of classes left. If you haven't picked a time to meet with me at the midterm, please do so too. Your time is dwindling to do that. About a week left to go. Any questions in general, things on your mind? No. Wow, you are all bundled up. It's jackets and everything. It's in the 40s? Yeah. Yeah, I was in Chicago yesterday. It was snowing. But then I get here, it's about the same temperature, so not much of a difference. Yes, no. All right, our topic today continues our discussion on the Fifth Amendment and the Takings Clause. The topics on the Takings Clause are divided basically in half. Most of the cases in this unit focus on the question of what it means to take property, right? At what point does a land use regulation become a taking of property that requires a payment of compensation? For example, a regulation of aesthetics, right? Does regulation of aesthetics amount to a taking? What about regulation of land use, 1-family, 2-family, 3-family apartment? What about zoning, like amortization, that you can't sell adult books, right? At what point does a land use regulation amount to a taking? The topic here is a little different, okay? The topic here focuses today on situations where the government is taking your property, right? In the case for today, Kilo, there's no doubt that property is being taken. The only question is whether it's being taken for a public use, right? The government can't take property for any reason whatsoever. They can only take property for public use. And in these cases, they want to take it, and they want to have to pay just compensation for it. So the question becomes, what exactly is a public use? There's some easy answers to this question, and there's some harder answers to this question. Traditionally, the obvious public use would have been something like building a road, right? Or maybe you need to use the power of what's called eminent domain to build some sort of government structure, a school or a military base, right? Something that serves the public. Maybe you're building a public park, which everyone can have access to, right? I think most people would agree that that's a public use. We have some more maybe borderline cases today, which involve railroads, right? that if the state wants to give a railroad company a monopoly to become a common carrier, then the power of eminent domain can be used to seize that land. We also have situations with pipelines, right? Pipelines that transport oil and gas function in a very similar fashion as would a railroad, right? It functions in a similar fashion as a railroad. How? What's that saying here? Uncle Kevin? What is that? Is that a joke?
Yeah.
Well, I don't get it. Who's Uncle Kevin?
Kevin Yamamoto.
Oh. Okay. Pipelines function in a similar fashion as railroads. So if a common carrier wants to build a pipeline across your property, they can also use eminent domain. Power lines, right? Everyone needs electricity. The government wants to bring electricity to a region. They may request an easement, or actually they may request actually seizing land to purchase a power line above you. Sewage. Right? You don't think of sewage, but sewage is important, right? If the city wants to dig pipes under your property to bring you sewage, I think that most people would agree that that's a valid public use. The sewage is taking up everyone's stuff, and it's something which everyone can use. Okay? So there are a lot of examples of eminent domain that people may not like, but we at least agree that it's a public use. But then there's some uses which aren't so clear that they're public use. The case I assigned today, Kilo, was from 2005. But there are two other cases that I want to talk about. The first is called Berman versus Parker. And the second is called Hawaii Housing Authority versus Midkiff. I think the Hawaii case was from 1981. I'll double check the year, make sure you get the right year. Yeah, sorry, 84, I'm sorry. That was my birthday, I should know that. And then Berman v. Parker, I think, was from 55. Let me just double check that. 54, off by a year. Okay. These are two cases that I want to discuss first before we get to Kilo. I always think maybe I should assign Berman in Hawaii, but I'm always conscious of reading. Oh, by the way, I was at yesterday the University of Chicago, and one of the people I met with was actually Strhilovitz. So in your textbook, the bottom guy's name, Strhilovitz. Usually on any book, the person whose name comes last does the most work. That's how it usually works. So he was actually the guy who was updating it. So I gave him some complaints and things I don't like, and he took it to heart. So he's listening. I complained again about the vertical privity arrows. Okay, we'll consider it for the next edition. Not that it affects you, but he heard the complaint. I'm actually thinking about doing a video series for property. You may know I have a book for common law, 100 Supreme Court cases. I'm flirting with the idea of doing 100 property cases and do the videos as well for them. I'm thinking about it, like 80% of the way there, but I'm working on it. So I gave you an email last night as the final night was recorded, well timed, with a video for Kilo. If you have a few minutes to watch it, did I send it to you? Oh, you know what? I sent it to the wrong section. Damn it. That's why no one got it. I sent it to the common law students by mistake. Okay, well, they can get it as well. They should. But actually, if you go in your syllabus, I added links on your syllabus. Under today's reading for Kilo, and under the readings on Tuesday for the regulatory takings case. So just read those or watch the videos. You'll get a sense for it. I may play a little bit of it later. But I made a video series for my common law class, and there are a couple actually property cases on them. So I may play a little bit of it in a minute. But first, let's talk about Berman v. Parker and Hawaii Housing Authority versus Midkiff. Oh my God, my common law students were so zoned they didn't even respond saying sent to the wrong class. It was obvious this for property students. They didn't even tell me. The reason why is Stanley, right? This thing, it's terrible. It's awful. There's no easy way for me to email all of you. I can't do it with any sort of easy way. I have to basically send an announcement to the class page, but how do we put this? It doesn't say property fall of 2019. It just gives a code, a number. And if I don't give the right number, then it sends it to the wrong section. So I think I sent your email to my common law student by mistake. Not one of them responded and even noticed. Anyway. All right, so let's start with Berman versus Parker. Berman v. Parker arose in the District of Columbia. Boo, right? Actually, very close to Nationals ballpark in Southwest D.C. Indeed, the Nationals ballpark was built using eminent domain. They actually had to buy people's land to demolish their homes to build the ballpark. So if you need another reason to hate, there you go. In Berman, you had the government who wanted to use eminent domain to seize an area of land for economic development. Okay, what does that mean? Some parts of this land were, homes. Some were small businesses, but it wasn't very profitable, right? It wasn't generating a lot of revenue. And the thinking was that if the government takes over the land, the so-called blighted area, they can build schools, they can build streets, they can build public facilities, and, oh, by the way, they can sell some of it to redevelopers. One of the residents who owned a store challenged him. And he said that his business was not blighted. Now, you may hear the word blight, right? B-L-I-G-H-T, right? Blight. When you think of the word blight, you think of this sort of, run-down home, right? It's abandoned, with like rats running around, with, smashed windows. But in property, the word blighted doesn't have the same sort of negative connotation. Blighted could just mean we don't like it, right? Maybe there's some cracks in the sidewalk, right? Maybe the building doesn't have the freshest coat of paint on the outside, right? Government defines blighted in a very, a broad sense. So in this case, you had one store that wasn't blighted, but there were other areas that were blighted. So in other words, he said, fine, take their homes, but not mine, right? It's not a public use to take my home. Okay, who wrote the majority opinion in Berman versus Parker? Our favorite, Justice Douglas, right? Justice Douglas wrote the majority opinion, Village of Belterra versus Boras, which you read last class. And if you recall, in Belterra, Justice Douglas said that we have to be deferential. We have to defer to the democratic process. And if the democratic process decides to seize the entire community, we can't tell them otherwise. Right? We can't say, take this, but not this, but not this. It's okay for them to take the entire plot of land as part of their discussion, as far as their comprehensive development plan. And he says nothing in the Fifth Amendment stands in this way. And one of the most important things that Justice Douglas did was he took the word public use in the Constitution and he explained that public use, ready, watch, actually translates to public purpose. There's a huge difference between a public use and a public purpose. A public use is land that's used by the public, right? A park, a road, a railroad for common carrier, a pipeline, which is a common carrier, power lines, sewage lines, right? Anyone can use those utilities, right? Anyone who lives there can use that railroad. Anyone who lives there can use that sewage, right? But public purpose is something different. Public purpose refers to something that might benefit the public, right? Maybe economic development, maybe increasing the ability of people to access homes, right? Make housing more affordable, maybe attract businesses, maybe increasing the tax base. Once you get to Berman versus Parker, which has this expansive notion of public purpose instead of public use, the Takings Clause looks like a very different provision of the Constitution. Okay? So any question on so far? The next case, beautiful, right? Beautiful pictures. The next case was from '84, about 30 years later. And it's called Hawaii Housing Authority versus Midkiff. Do you remember a case from Property 1 involving marital property called Sawada versus Endo? Remember there was this couple in Hawaii, they got into a car accident, and they didn't have insurance. Did you do this case? No, okay. Never mind. It's in your book. All right. Hawaii had a problem. Okay, what was the problem in Hawaii? There wasn't a lot of land. And most of the land was owned by a few very wealthy families and businesses. The land belonged to what was called an oligopoly. Not a monopoly like railway. Not one. Oligopoly means several. So there was a shortage of fee simple land. It was very hard to actually acquire land in fee simple. So what did the Hawaii government decide to do? What do you think they did? They used eminent domain to take land from the private landowners and give it to tenants. So if you were leasing a piece of property, the government basically bought the land from the owners and transferred it to the tenants. So you went from being a lessee to a fee simple owner. Why did they do this? The purpose of this regime was to increase the availability of fee simple property, to break down this land oligopoly. Right? Was this a public use? The court says yes. And in fact, Justice O'Connor, who I think had been in the court of 3 or 4 years at that point, wrote the majority opinion. And she argued that the state's purpose of eliminating the social and economic evils of land oligopoly was a public use, or more precisely, a public purpose. In other words, once you get from public use to public purpose, the government can get away with a lot more, to seize land to try to increase economic development. Does it actually have to work? Right? Does it actually have to generate any economic development? Well, that's not required. Under the Douglas approach of deference, the courts do not second guess the wisdom of the decisions. The courts will merely defer to what the government decides is appropriate. Okay. Questions so far? All right. Who am I up to? Who's next? Thank you, Matt. All right, Matt, you want to walk me through, please, the facts in our only case, the facts in Kilo.
Kilo. All right. So, in about 2000, the city developer created a plan to create about 1,000 jobs, increase tax and other revenues to revitalize the economy. City developer agent first went about trying to buy the property of those willing, and after that used the power of eminent domain to obtain property from those unwilling.
Okay, very good. All right. This story is actually true. Several years ago, I was at a conference in Yale in New Haven, Connecticut, and I decided to drive from New Haven to London, which is like about a 2-hour drive. So I wanted to actually take pictures of where the little pink house was. This is a true story. So I'm driving around town, and first I visit the Kilo house. The actual Kilo house was moved. I think I have some pictures of it towards the end. Plank by plank. Here, there it is. They actually took the house apart after she lost her case, and they moved it across town. And I visited the house, and now there's someone else who lives there. It's almost like a museum. Like, people live there, but there's like a little plaque saying this is the Kilo house. Okay. Then I took a drive over to this empty lot. This is the empty lot where the Kilo house was. Okay, but before I got to this empty lot, I was driving around the neighborhood and I made a wrong turn. This is a true story. And oh, by the way, of course, I was this idiot. I had my video camera and I was filming everything. So I was basically driving with one hand and my camera in the other hand, driving around the town. And I make a wrong turn, and I pull into this office complex. the company is called General Dynamics, which is a military contractor, which is right by. And I'm like, oh, okay, whatever. So I start turning around, and this Jeep pulls in front of me. Like, oh, crap. And like his lights come on. Like, oh, boy. And this huge guy gets out of the car. He's like, what? He's like, what the hell are you doing? And I'm like, okay, how do I explain this? I was like, I'm a property professor, and I'm recording the kilo counts. He's like, he says no. He's like, give me your license. I'm like, oh, I thought I was getting arrested. I was actually getting worried. So I said, look, here's my camera. I'll delete whatever pictures I have. I'll show you my camera, and they let me go. So I don't actually have the footage that I had because I had to delete it. But I went back to some other pictures later. But it was harrowing. I was close. I forgot to getting arrested. It was close for the sake of my in-grade property students. I didn't watch the damn video because I didn't say the right link. But anyway, I took some stills. So I do have some still pictures. This was in 2012 or 13. I still had an actual video camera back then. The times have changed. But this is the lot where Kilo's home was. Okay. As you can see, the entire lot is empty, except that thing in the corner. What is that thing in the corner? That thing in the corner was a men's club called the Italian Dramatic Club. That's where a lot of the local politicos went to go hang out. So effectively what happened is the city designated this entire area as distressed. And they decided to use the power of eminent domain to seize this property. Except for one portion of it on that back corner over there, which is a little bit mafioso. I wasn't quite sure, but you can just do the math. But they didn't take that one part at the end. All right. Now, here's how the process usually works. First, the government says, we'd like to buy your property. And you say, no thanks. And they say, then the government comes back and says, we'd really like to buy your property. And you say, get lost. Government comes back another time and says, well, if you don't sell it to us, we will go to court. And we will have a court order you to sell it to us. Okay. At that point, once you go to court, the government has only one job, which is to show that the compensation they're giving you is just. They don't need to justify why they're taking it. Now, in this case, Kilo argued that the taking was not for a public purpose. I'm sorry, was not for a public use. That it was for private economic development. Yes, Stephen?
Is that part of the same suit, or is it like a cross
I'm going to answer this question tentatively. Eminent domain litigation is very complicated. In some states, the way it works is the state comes to take your property, and then in that same suit, you raise as a defense that's not for public use. In other states, what you have to effectively do is you have to sue for an injunction state court to block the taking. I think in the New London case, I can't remember who sued whom. I'm blanking, but it's either one of those two options. Okay. So Kilo, and I'll show you a picture of her, said that she did not want the government to take her little, that's me, her little pink house. If you see a sign that says not for sale. Now, why did New London want to take the property? Pfizer, the pharmaceutical company, had a strong interest in building a research facility in that area. It's a beautiful waterfront property. Now, one important point. Pfizer wasn't just going to be the sole beneficiary of this. The government said that if Pfizer comes, they'll employ people, right? There'll be new construction. There'll be contributions to the tax base, right? This wouldn't just be for benefiting Pfizer, or at least that was the plan. But there's some very good evidence that the circumstances were shady. That apparently Pfizer made a no-interest loan to the city to help them out. And, you know, land dealings are often very, I don't use a bad word, suspect. That's good, suspect, right? That land developers generally have to do things that aren't always up above board to get things done. That's often how things are done. All right. So the plan was we use eminent domain. We take Suzette Kilo's home, as well as the homes of those surrounding areas. Many of these people live there for decades on end. And then once it's owned by the government, you then sell it back to Pfizer at a reduced rate, with the hope that they give an economic boost, a rejuvenation to the city. Okay. Let me actually play some of this video. I usually don't do it, but since I forgot to send the link last night, I'll do that. I'll give you the background. In con law, I'm on a con law casebook. I'm a co-author with Randy Barnett at Georgetown. And we made a series called 100 Supreme Court Cases Everyone Should Know. And we produced a video library about 11 hours in length with these short videos about every case in the book. And one of the cases in the book is Kilo. Let me just play this and give you guys some, maybe a little lighter load today because of the crushing loss last night, I suppose. Okay. No?
In 1990, a state agent
And that's Justice Stevens' voice.
The city of New London as a distressed municipality. The city formulated an integrated development plan that focused on 90 acres of the city's Fort Trumbull area.
The plan was to use eminent domain to take property in the Fort Trumbull area and transfer it to Pfizer. The pharmaceutical company pledged to construct a new research facility.
The city expected that the plan would create new jobs, increase tax and other revenues, and improve the area's recreational opportunities.
Initially, New London tried to purchase the homes in Fort Trumbull, including Suzette Kilo's little pink house. However, Suzette Kilo and the other
Petitioners, some of whom have lived in their houses for their entire lives, refused to sell.
their property. As a result,
The city commenced condemnation proceedings to acquire their properties in exchange for the payment of just compensation.
Kilo and the other
Petitioners brought suit in state court to enjoin the condemnations, alleging that the taking of their properties violated the public use requirement of the Fifth Amendment.
Specifically, Kilo
Argue that an economic redevelopment project does not qualify as a public use because most of the condemned property will ultimately be owned by private parties.
Justice Scalia aptly summarized Kilo's objection.
What this lady wants is not more money. No amount of money is going to satisfy her. She's lived in this house, her whole life, and she does not want to move. You say, I'll move if it's being taken for a public use, but my God, you're just giving it to some other private individual, because that individual is going to pay more taxes.
The question presented was
Whether a city's taking of private property for the purpose of economic development satisfies the public use requirement of the Fifth Amendment.
by a vote of 5 to 4, the court ruled against Kilo. The justices were divided on the appropriate constitutional standard. The text of the Fifth Amendment requires a, quote, public use to take, quote, private property. Yet many justices equated public use with public purpose. For example, Justice Souter asked,
Yep.
Why isn't there a public purpose here?
So even during the arguments, the justices were using the phrase public purpose instead of public use. And Scalia pounced on Souter very quickly.
Justice Scalia interjected,
Does a public use requirement mean nothing more than that it have a public purpose?
study guide.
All right, I'll come back to this in a few minutes. Yes?
So, I guess with that interpretation, does that mean that won't continue now with these? There are private individuals who really don't win anymore with any kind of suit or defense?
Well, it's a good question. So the question is, does anyone win anymore? Does a homeowner ever win? under the federal Constitution, the answer is probably not. After Kelo and Justice Stevens' majority opinion, virtually anything is a public use. A number of states actually enacted legislation following Kelo to try to restore more protection for property rights. This was a very unpopular decision. No one liked it. Unfortunately, many of the laws passed by the states were pretty ineffective, right? So, for example, let me just pull the one up in Texas. I have some notes on it. In 2009, Texas enacted what's called Amendment 11, which forbids taking for economic development, which sounds great, right? So under Texas law, the government cannot take property for economic development. But, unfortunately, the phrase blight is defined so broadly that almost any property can be taken for blight. For example, in Texas, blight can include economic or social liability to the municipality. In other words, if there's a piece of property that causes a social or economic liability, then that property is blighted. And the state government in Texas can then seize it through eminent domain. Right? Almost any property can cause an economic liability without fail. Additionally, in Texas, the government can give eminent domain to private organizations, for example, oil and gas companies and the like. So even in Texas, you might think is a fairly, or was fairly conservative state, the laws are not particularly strong in eminent domain front. So in other words, you're probably still going to lose. Hope that was not a too depressing answer to your question, but there it is. Yeah. The problem, though, for the court, though, was, let me put it this way. You're a litigant, right? You go to court, and you have to argue this case. Can you ask the court to overrule all these old decisions, right? Can you go to the Supreme Court and say you need to overrule Berman v. Parker, 1954, and you need to overrule Hawaii Housing Authority versus Midkiff, 1984, right? Oh, I guess, Ethan, can you go to Supreme Court and ask them to overrule these cases?
I think so. I feel like you just use them in your argument and they decide against it.
Yeah.
They decide to go against old precedent.
Yeah. It's very difficult to go to the court and ask to overrule a precedent. They don't like doing that. So as a result, Suzette Kelo's lawyer had his hands tied. And he had to try to argue within the existing case law that Kelo's situation was different.
Argued that, or could you just maybe ask to limit holdings to those cases instead?
Oh, that's a good one. What does that mean, limit a holding to those cases? What does that mean? It's a great expression, but what does that actually mean?
Just Berman and Midkiff are limited to those cases, and they won't apply to
Anywhere else. How is that different than overruling them?
because they're not saying they're like bad precedent or anything. They're just saying that.
But can you cite those cases going forward?
No,
So how's it different than overruling them?
I mean then they don't have to outright say that they're overruling.
Yeah. I'm mostly giving you a hard time. You're right. I do that, right? Very often the courts will say, we limit the case to the facts presented. That means you're overruling it, right? What that means is you can't cite it as precedent anywhere else. How's that different than overruling it, except you don't say we're overruling it, right? This is more of a common law-ish question. This is what I told Lior yesterday, Shrilovitz, that teaching this unit is like a different class altogether because it's about the Supreme Court. And I don't like the Supreme Court properly because they screw stuff up consistently. Courts will often say, this case is one of a kind, right? That the facts here are so unique that we should not extend this analysis elsewhere. The most famous, or perhaps most infamous case along those regards was a case you've probably heard of from 2000 and the election called Bush v. Gore, right? That was a case that I could teach an entire semester on. I don't even teach it, but I could. And the court basically said that the analysis here is limited to the facts of this case. So it wasn't you're limiting some case from 50 years ago, right? It's the case we're deciding here. The analysis only applies to this case. In other words, don't cite it anywhere else, please. Just, in other words, this is such a stupid opinion. We don't want you looking. We don't want you using this precedent, which is a weird thing for a court to say, right? Because courts aren't supposed to decide cases just for here and now. They're supposed to establish general rules that may apply in a wide range of circumstances. So I think your question is, limit to the facts here. The court couldn't well do that because there'd be another property case comes along 5 minutes later. But yeah, does the facts apply there? So the lawyer for Ms. Kelo, his name is Scott Bullock, it's a friend, he couldn't argue to overrule Kelo. I'm sorry, overrule Berman and Midkiff. So he had to follow those cases, right? So he tried to make an argument about economic development, right? Where if a taking is solely for economic development, that's not a public use. Morgan, how did that argument work for him? No, it didn't work for him. Walk me through the court's analysis in that front.
Well, they said that that they had to determine whether the taking was reasonably necessary to achieve the intended public purpose, like the course of the city, and whether the taking was reasonably necessary. And they said that in Midkiff,
Midkiff, yep.
yeah, the city, that under that, the city couldn't take land for the purpose of conferring private benefit on a particular person, but the city would be allowed to if there's any kind of purpose. It would
Okay.
just be like a pretext purpose.
Okay, very good. I think you said a few things there that are important. Let me go through one at a time, right? The overriding feature of the majority opinion is one of deference, right? The court says that we will show deference when the government exercises their police power, right? The court says the government can't simply take property and give it to a private party, right? They can't pretend to have a public use when the actual purpose is to bestow a private benefit. But in this case, we're not worried about that, right? Why are we not worried? Because there's a plan, right? There's a comprehensive, careful plan. And this plan is not adopted to benefit any particular individual, right? The plan is to improve the community as a whole. Now again, the court acknowledges that this land will be used for private purposes, but they say there's no requirement the land's actually used by the public. That is, public use does not mean used by the public. Everyone just get that? Right? Public use in the Constitution does not mean used by the public. Right? If I walk into the Pfizer headquarters, the guy will arrest me and throw me out the door. Right? You can't use it. All that matters is whether there's a public purpose. And here the court relies on Berman from 54 and Midkiff from 84. And there's no broad formula. They stick to their settled doctrine. Here the court finds that economic rejuvenation is a good plan, and it's one that's entitled to deference. New jobs and increased tax revenues. And they reject the idea that you can draw a line in economic development. All right? Because if you think about it, the Midkiff case in Hawaii was about economic development. And in Berman versus Parker, the city was trying to improve the economic well-being of the neighborhood. Now, is there any requirement that you have to submit evidence that you'll actually improve the economy? No. They say as long as there's a reasonable certainty that public benefits will accrue, they're not going to second-guess the developers. Okay. Okay. All right. right. Elizabeth, what did Justice Kennedy say? Justice Kennedy would always do this thing where he would join the majority opinion and say, I join, but here are my separate thoughts, and you guys should know I'm actually the majority, right? I'm actually in control, not Justice Stevens, right? He needed my vote in this case, and I gave it to him, right? It was a 5-4 case. So Kennedy writes this sort of brief concurrence. It's kind of weird, but he adds some thoughts, some observations.
So he said that it should not survive the public test because it did actually favor the private party.
But what's Kennedy worried about? He has like a concern of where this problem may go awry. He has a concern. She's pointing to your book. It's not in your book. It's in the supplement I gave you, I think, isn't it? Isn't the didn't I put in the syllabus for you the Kennedy opinion? Is that in your book or is that not? I can't remember. I linked to it, didn't I? It's there. It's there. I know I signed it. Yeah. Yeah, it's in the book. Oh, it's the Thomas one that's not in the book, right? Okay. What's Kennedy worried about, Elizabeth? What's his concern? It's not in your book? Kayla?
I thought you were talking about that there needs to be a more stringent standard of review.
When? In what circumstances? You're right, but he...
When they're taking somebody's property, right?
Well, they're always taking someone's property, but what triggers in Kennedy's mind a more stringent standard review?
For economic development?
Specifically, yes. I'm looking for a specific thing of when. Right? Just because there's economic development doesn't mean you have heightened review. When do you need it? No, Danny?
It says when there's a clear showing that its purpose is to favor a particular private party.
Yes.
Incidental.
Yes, that's right. It's in your book, right? Yeah, it's there. Kennedy writes in language that's not meant to be understood. Only by him, perhaps. But you see that now, Kayla?
I do.
Elizabeth, you see it now? Okay, good. Kennedy is he's always worried about favoritism, right? Where the government picks winners and losers. And if they pick one person as the winner, they may disadvantage others. So he says, generally you apply what you might call a rational basis standard of review, where you're very deferential. But there might be certain circumstances in which there's evidence of favoritism, right? That they took this land to favor one person and harm another. And in those cases, can he be willing to apply more rigid review? Now, again, this is the case. If you look at the block where her house was taken, everyone's land's demolished except for this one house, which was a well-connected political club. And even the members of the government promised this club, we're not going to take your property because they need the support for the plan. So this is, even in this case, by Kennedy's own terms, there should be heightened scrutiny that's being applied. Okay? And here's the quote, I think, which I'm almost certain is in your book, where it says, where there's a particular class that's being injured, and there's only pretext, fake public justifications, you may use heightened scrutiny. This one's in your book, right? No? Kind of? I actually complain about how they edited this case. I complain about a lot of things. Anyway, but there it is. If you want to write it down, it's there. Okay. Questions on the Kennedy opinion? All right. Justice O'Connor wrote the principal dissent. And I want to just play a little bit of the O'Connor one, right? Justice O'Connor was worried that if the Kelo rule takes hold, then no one's property is safe, that anyone's property can be taken at any juncture. Let me just play a little bit of this.
Justice O'Connor asked a lawyer from London if the government could take a Motel 6 in order to replace it with a Ritz-Carlton that could generate higher taxes. Now, is that okay?
That's harder than that's actually harder than you think it is. Actually splice up the audio and make it sound not awful. Because what happens when they ask a question, it's like a 30-second question, only 2 words are important, right? It sort of just meanders. So So the question is, could you take a Motel 6 and replace it with a Ritz-Carlton? What do you think the lawyer for the government said?
In a gutsy move, Wesley W. Horton bit the bullet.
Yes, Your Honor, that would be okay.
So the government went in there and said, yeah, we could take a Motel 6 and make it into a Ritz-Carlton. He admitted it. He had to, right? Because the second they say, no, we can't do that, your argument falls apart. It's all or nothing.
Kilo's lawyer dismissed his argument.
Every home, church, or corner store would produce more tax revenue and jobs if it were a Costco, a shopping mall, or a private office building. But if that's a justification for the use of eminent domain,
I love Costco too.
then any city can take property anywhere within its borders for any private use that might make more money than what is there now.
In her dissent, Justice O'Connor agreed, quote, under the banner of economic development, all private property is now vulnerable to being taken and transferred to another private owner, so long as it might be upgraded, that is, given to an owner who will use it in a way the legislature deems more beneficial to the public in the process. Moreover, the court washed out any distinction between private and public use of property, and thereby effectively deleted the word for public use from the takings clause of the Fifth Amendment. Justice Thomas has
All right, we'll get to Thomas. We'll get to Thomas in a minute. So the O'Connor point was that this this majority basically allows the taking of property from A and giving it to B. And by abolishing the line between public use and public purpose, by making those blurred together, there is no limit. Of course, one of the ironies is Justice O'Connor wrote Midkiff, right? In 1984, she wrote the opinion upholding the Hawaii eminent domain policy. She didn't this is Morgan's question. She didn't want to overrule her own opinion, right? O'Connor didn't want to limit. She said, okay, we'll just limit it to those facts, I guess, right? Where she said, no, that's different. But in my opinion, what do I know? I think Midkiff supports Kelo in many regards. So the Kelo lawyers were basically in a tough spot. They couldn't say overrule Midkiff, that's work within it. By working within it, they were basically destined to lose, at least 5-4. O'Connor doesn't say overrule it, but she comes very close to saying it. Okay. Now, under the rule in Kelo, any property can be taken for the benefit of the private party without judicial scrutiny. Okay, questions on the O'Connor dissent? All right, let me play a few minutes of the, actually only 3 minutes left. I'll play the Thomas one as well.
He, quote, would revisit the court's public use clause cases and consider returning to the original meaning of public use clause. That the government may take property only if it actually uses or gives the public the legal right to use the property. Finally, Justice Thomas predicted that, quote, extending the concept of public purpose to encompass any economically beneficial goal guarantees that these losses will fall proportionally on poor communities. Those communities are not only systematically less likely to put their lands to highest and best social use, but are also least politically powerful. Here, Justice Thomas faithfully cited footnote 4 of U.S. v. Carolyn Products, 1938. Quote, if ever there were justification for intrusive judicial review of constitutional provisions that protect discrete and innocent minorities, surely that principle would apply with great force to the powerless groups and individuals the public use clause protects. The Kelo majority stated that it was irrelevant whether the city's plan ultimately led to economic development.
It is not within our authority as a court to determine the plan's likelihood of success, nor to determine whether New London would have been wiser to pursue economic development in some other way.
Okay, so Justice Thomas approaches from a bit of a racial angle. In American history, eminent domain has been fairly common in places where there's poverty. Berman versus Parker was not an impoverished area, but was not well-to-do. And generally, the people who are best equipped to fight eminent domain will not have their homes taken. Instead, the government will focus on those who are least equipped to seize property because they don't have lawyers, they don't have litigation, they can't afford the legal process. Thomas says this will fall predominantly on people who are poor and probably racial minorities as well, people with lack of education. Thomas also explains that there's no guarantee this will actually generate economic development. This could all go up in flames, go up and bust, which is exactly what happened.
Nonetheless, during oral argument, the attorney for New London offered lofty assurances.
And the expectation is there's going to be a demand for Class A office space, which is the best quality office space in this area by 2010. And the expectation is that it will attract the sorts of offices that will feed on the Pfizer. They spent $300 million on a site here.
Did they ever build it? Nope.
After Kilos decided, Pfizer chose not to develop a new research facility in New London.
They merged with Merck, another pharmaceutical company, which had a research plant across the river. So they didn't need another one. So nothing was ever built.
A decade later, the former site of Suzette Kilos' home remains an empty lot, occupied only by feral cats.
I didn't see the cats, unfortunately.
Kilos'
I was looking for them, but I didn't see them.
It now stands as a monument to eminent domain.
And there's a movie called The Little Pink House. I didn't like it. Most court movies are not very good, and this was one of them. I really wanted to like, cause I love the people involved, but just it's Catherine Kinnan in it. She's in some movies. It was okay. It wasn't terrible, but I didn't like it. Anyway, but it's on a Google Play and all the other stores, so you can maybe stream it, a few bucks, but it's out. I do want to show you. I have a clip though of Kilo talking.
My name is Suzette Kilo. I live in New London, Connecticut. And I am Kilo in the Kilo versus the City of New London, the now infamous United States Supreme Court case in which the court ruled that private property, including my home, could be taken by another private party who promises to create more jobs and taxes with the land. This battle against eminent domain abuse may have started as a way for me to save my little pink cottage, but has rightfully grown into something much larger. The fight to restore the American dream and the safety and security of each and one of our homes. Thank you very much.
More than 40 states enacted some form of eminent domain reform to curb in the reach of the Supreme Court's decision. However, many of these reforms were largely ineffective.
And Randy Barnett is now wrapped.
Oh, this was the last video. Okay, that was the blooper reel. Yeah, Easter egg, right? If you stay till the end, that's actually the last video after 11 hours. Put that one at the end. See who was paying attention. Anyway, so the upshot of the Kilo case is absolutely nothing was built there. It's still an empty lot. There's been zero development, and the city's still economically depressed. The lesson is very rarely do these eminent domain plans actually ever pan out. In fact, the governor at the time, who was pushing this, I think he got out, but he was in jail for some time. The governor of Connecticut. He was also involved in trying to lure the New England Patriots to play in Connecticut, and actually Bob Kraft was just using him to get money to build a stadium in Foxborough. It was just this entire ploy. So basically, he got played by everyone, which is why government people should not be in the business of trying to acquire property because they get played and they get nothing comes of it. Okay. Questions on Kilo? All right. I'm fishing early. I think at least one of you had office hours later. If you want to come by now, I'm free to meet now. Otherwise, I will see you all on Tuesday. Have a happy Halloween. Go trick-or-treating and enjoy.